As landlords, we enjoy the benefit of having a passive income on our investment. With investment, there is also risk. The most common risks faced by landlords are rental-related, preservation of the property, and tenants' behavior. Here are a few things landlords should take note of. Before entering into an agreement to rent, the landlord should conduct his own due diligence on the tenant instead of relying on the real estate agent. When a problem arises after the signing of a tenancy agreement, the landlord cannot hold the real estate agent responsible as the buck stops with him. For example, the Immigration Act 1959 states that anyone who rents a property to an illegal immigrant shall be liable to a fine of up to 30,000 ringgit or imprisonment of not more than 12 months, or both, for each illegal immigrant remaining on the premise, and that is only if it is his first offense. Apart from getting copies of the tenant's identification documents, it is also important to confirm the identities and the number of people who will be staying there. No one wants to hand over their investment to someone who is of dodgy character, isn't it? Get to know them first, as it could make a big difference. It is fundamental to have a good, with a capital G, comprehensive tenancy agreement, as this sets out the rights and responsibilities of the parties. The problem is, most tenancy agreements in Malaysia are template agreements supplied by the real estate agencies. Not trying to downplay the real estate agency here, but template agreements can be dangerous if they are not applied properly. The reality is, most people won't read them when they are told that this is a standard agreement, even though they are not. Unfortunately, template agreements lack individuality. They are not tailored to the specific needs of certain landlords. Some are even archaic. Hence, it is vital to have a comprehensive tenancy agreement which is in sync with updated legal principles. At the beginning of each tenancy, the landlord should take an inventory of the premise. It is recommended that photographs are taken together with the tenant to confirm the condition of the premise. This is to avoid any dispute on damage caused on the premise or any unapproved alteration made to it. The parties can confirm the condition of the premise by attaching the photographs on the tenancy agreement or by an exchange of emails. Though surprise visits are not recommended, a scheduled visit to have tea with the tenant or an excuse to drop by to hand over your leftover meatloaf can provide a perfect undercover to assess the condition of the premise. This can also double up as an opportunity to get to know your tenants. Hence, throughout the duration of the tenancy, it is important for landlords to build a rapport with their tenants. Not only will this encourage the tenant to be candid, it will also deter them from doing anything that would offend the landlord. When a breach occurs, one should issue a notice to the tenant at the earliest possible opportunity, requesting him to rectify the breach. If the tenant rectifies the breach, the matter is then resolved. But if the tenant fails to do so, the notice will serve as evidence of when the landlord first came to know of the breach. The landlord can then consult a lawyer to obtain the desired remedy. For rent in areas during the tenancy period, a landlord can recover them by way of a writ of distress pursuant to the Distress Act 1951. If the claim is below 5,000 ringgit, one can file a claim at the Small Claims Court. For the period the tenant holds over the premise after the expiry of the tenancy, the Civil Law Act 1956 allows the landlord to claim for double rent. If the tenant damaged the premise, the landlord can sue before opting to deduct any amount from the security deposit. If the tenant vandalized the premise and had absconded, lodge a police report and sue the bastard. If the landlord wishes to evict and recover the possession of the premise, the landlord can do so provided that the court order is obtained under the Specific Relief Act 1950. The truth is, going to court will take time and cost. Hence, this should be regarded as the last resort. Self-help remedies like cutting off electricity or water supply or forcibly enter the premise is not advised, as it may result in unfavorable ramification. In some cases, the courts even regarded them as illegal acts. People respond in accordance to how you relate to them. If you approach them on the basis of violence, that's how they will react, says Nelson Mandela. It is therefore important to understand the reason and difficulties the tenant is facing to negotiate an alternative. For example, if the issue is rental related, offer the tenant a reduced rental option. If the issue is damage caused to the premise, offer to bear a portion of the cost of rectification. Cutting your losses can be a more practical approach as long as you are agreeable to do so. If parties are unable to negotiate an alternative, perhaps one can also consider engaging a mediator to help the parties to do so. He is, after all, a trained professional, and it would be speedier and less costly as compared to resolving the matter in court. In summary, though this may seem to be a mundane chore, landlords must be vigilant and play a more active role. We are talking about your investment after all.